How do objections work during opening statements in a trial? Imagine sitting in a courtroom, hearing the lawyers outline what they think the evidence will show. It might seem straightforward, but there's a lot happening behind the scenes. When it comes to opening statements, objections are a key part of keeping the process fair. They help make sure neither side oversteps or misleads the jury. During opening statements, lawyers are not supposed to present evidence or argue the case. Instead, they give a preview of what they expect the evidence to prove. Because of this, objections are usually about two main issues. First, if someone misstates the law, like describing the wrong burden of proof or the wrong elements of a crime, the other side can object. This helps protect the defendant's rights and keeps the legal standards clear. Second, objections can happen if a lawyer tries to argue facts or make inflammatory statements instead of just previewing evidence. For example, if a prosecutor says, "We will prove the defendant is guilty beyond a reasonable doubt," that might be seen as arguing the case. Defense attorneys can object if the opposing side crosses into that territory. The goal is to keep opening statements as a fair preview, not a full argument. Courts usually allow some flexibility in opening remarks. Defense lawyers often outline their theory of the case and may suggest witnesses might lack credibility. These are not considered arguments but expectations. If a lawyer says, "We expect the evidence to show," it's generally acceptable. But if they start making unsupported claims or inflammatory comments, objections can be raised. When an objection is made, the judge will decide if the statement is okay or if the lawyer must stop or rephrase. If the judge agrees with the objection, the lawyer must change what they said. If the judge overrules it, the statement stays, and the case can address it later during the trial or closing arguments. Objections during opening statements are there to keep the process honest. They help prevent the prosecution from misrepresenting the law or making improper arguments early on. For the defense, they're a way to protect their client's rights and ensure the jury gets a clear, fair picture. At the same time, lawyers need to balance objections with the chance to tell their side's story. Opening statements are a chance to shape how the jury sees the case, so knowing when and how to object is an important skill.